All right. Well, I want to thank everyone for being here today for the Judiciary Non-Civil Committee. What we'll do is we'll lead with our invocation and then give everybody a minute to come up and sign up. So, Chairman Fleming, will you hit your button, please, for us? All right. If we could have order, please.
If you would, please bow your heads with me as we open this meeting with prayer. Lord, we thank you for the opportunity once again to begin this meeting. We thank you for the rain, although we realize we've had a good bit. We also appreciate the sunshine. But there's so many blessings around us. When we get consumed sometimes with our duties here, we should never forget how fortunate we are to live where we are and have the opportunities that we do. Help us to remember that now as we begin this meeting, and as always, bring the wisdom in this room to help us do what's best for the people of the state of Georgia. Amen.
Amen. All right, so as we mentioned, we have a sign-up sheet which is available here if folks want to. David, how are you? Want to come on up and sign up?
It's going to be a marathon.
Yeah, it's all right.
Might top last night. I'm
Seth's
leaving at
learning here.
2, and then
Yeah, and then
I'll be back.
All right, I tell you what, Mr. Norris, will you please take the sign-up sheet with you? Let's go. Let's put the sign-up sheet back here so we can go ahead and get. We got a few legislators here who are ready to go, and what we'll do is we'll go ahead and call HB 1083. There's a substitute in the folders. And so I see Representative Petrie is here. And, Mr. Chairman, are you ready to go? All right. Very good. If you'd like to proceed with your substitute, HB 1083.
Who is going to speak to this bill as well. We have, both have been working on versions of this bill and have come up with a substitute that we believe is dramatically better than where we began. And that's what we're speaking to today. And so, let me get my information here. So if you will look at LC 289709S. Does everyone have a copy of that substitute? That's 289709S. Okay. That is the bill we're discussing, substitute House Bill 1083.
So, Kyla, tell you what, why don't you use Representative Kendrick? You use, okay, you do have it. All right, go ahead.
Okay,
sir.
thank you, Mr. Chairman. And again, so let me be clear about a couple of things first, and then we'll go through this bill. I want to be real clear, Mr. Chairman. First of all, we're not here today to discuss immigrants. We are here to discuss public safety. Absolutely, that is the case. The current sanctuary city law that was passed in Georgia in 2009 merely pertains to the communication of information. It does not in any way address ICE detainers in any way, shape, or form, and doesn't even mention them in the language. And therefore, it does not protect the people of this state. Indeed, some of you are aware, because I've mentioned this before, just in the Georgia prison system alone, in our state prisons, not to include our jails, and I have a copy of that here before me, there are today 1,600 violent criminal aliens in our state prison system with ICE detainers, okay? And so this bill you have before you now is a 2-page bill, and it's pretty simple. And I want to begin, though, before we go through it item by item, I want to begin by addressing a question that I would expect that we all ask when we talk about any bill, and is, why do we need this? You know, because some people try to suggest that there are no sanctuary policies being used in Georgia. And so Representative Singleton has actually done a great deal of research on this, so I want him to tell you first about multiple policies and practices that are taking place in Georgia today. And then, after we go through this bill, I want to make sure everyone is aware that we have with us today Mr. Thomas Giles, who is our new regional director, acting director of ICE here in Atlanta. And we're very, very pleased to have him with us today, and we're going to have him make some remarks as well. But first, let me, Representative Singleton, explain some of the policies being used in Georgia today.
Thank you, Mr. Chairman. Thank you, Mr. Chairman and committee. Georgia sanctuary policy does exist in the state of Georgia. I'm going to refer to a 2018 study done by the Federation for American Immigration Reform. And it's important, I'll explain in a second why it's important to have a start point, but that it's not comprehensive. So just if you go back to 2018 audit, here's just a few of the sanctuary cities and counties that existed in Georgia. Athens, Clark County, the city of Atlanta, Clarkston, Clayton County, Decatur, DeKalb County, Fulton County. Some of these are policies that exist at the Board of Commissioner level, such as no detainer compliance without written agreement. Some of them are at the higher level, just statements from sheriff's deputies or from city officials saying we will not honor ICE detainers unless ICE presents the sheriff's office with judicially issued warrants authorizing detentions, and a whole myriad of things in between. What is important about the deficiency in our current code, which I know we'll get into at the chairman here and we'll get into later, is the language of the code is insufficient to make sure that it closes those gaps, and it does not account for the significant amount of, it's not just policies, but it's the procedures. And so that's why we're very honored to have our law enforcement professionals here to not talk political facts, but to talk actual facts on the ground. Because one thing that is why we as a state, and it should be a bipartisan effort to keep Georgians safe, why we as a state need to codify the correct language in the code, is because the safety of our citizens should not be up to the subjective application of the law by our law enforcement professionals or by local jurisdictions. It's important that we make sure, as the director I'm sure will testify, there are some places, localities in Georgia that have sanctuary policy, but because of leadership changes, whether it's at the sheriff's department or higher, they are working with our ICE officials and are not effectuating that policy. And there are others that do not have a sanctuary policy in writing in place, but in effect through their procedures are affecting sanctuary policy. So we appreciate your gentlemen's time, and we thank you for hearing this.
Director, if you would be willing to head over to the podium now and just present some, well, just tell us anything that you want to, and then to the author, if you would hold tight and then give us a brief walkthrough when the director finishes. Thank you.
No, it's all right. All right. Thank you, Mr. Chairman. Good afternoon, everyone. My name is Thomas Giles, and I'm currently the Acting Field Office Director for U.S. Immigration and Customs Enforcement and Removal Operations Field Office here in Atlanta, Georgia, which covers the states of Georgia, South Carolina, and North Carolina. Thank you again for inviting me to speak with you about how our agency works and how any laws you consider could negatively or positively impact the mission we carry out every day. First, I want to make it clear that our presence here is neither to persuade or dissuade you on the laws the people of Georgia have elected you to deliberate. Our role is strictly in a technical advice capacity, and we are happy to answer any of your questions. I must also thank you on behalf of the agency for asking us to be here today to provide this technical expertise. One thing that we know is certain: there are great misconceptions about ICE's policies and procedures. We believe everybody wins when people have all the facts about the real-life consequences associated with laws that impact how we work each and every day. In a nutshell, the agency holds that there is a human cost associated with sanctuary laws and policies, which ban local law enforcement agencies from working with ICE to include even the simple sharing of information about criminals in their custody. Laws and policies like these make us all less safe. It's unfortunate that in some states and jurisdictions, politicians are making decisions about how local law enforcement agencies should work with ICE in putting public safety at risk without any consideration of the real impacts. The type of cooperation that is most effective is how we work with most law enforcement agencies across the country. ICE utilizes a decades-old process in which we issue an official immigration form called a detainer to advise our law enforcement partners that we have established probable cause to believe that an individual who has already been arrested by that jurisdiction and placed in that agency's custody is an alien who is removable from the United States under our immigration laws. The detainer asks our law enforcement partner for two things. One, advance notice of the alien's release from custody, and two, a brief continued detention of the alien in our partner's custody until ICE can be present to take the individual into federal immigration custody in a safe and secure setting. Here's how we know an alien is in custody at a local jail. When someone is arrested, and only arrested and booked into its custody, is ICE able to see if that individual has any previous encounters with the Department of Homeland Security. Generally, their fingerprints are shared with the state's ID Bureau. Then they are shared with the FBI, and the FBI shares that information with us. This gives the local law enforcement agency and ICE that person's entire criminal and immigration history. This doesn't mean that's the only way we are able to find out if someone may be of ICE interest. It also means that if that person has not had any previous encounters with ICE, ICE may not know that person is sitting in your jail. Unfortunately, some jurisdictions have limited the cooperation with ICE or not allowed ICE into the jails to do our jobs. It's much safer and more efficient for all involved if ICE is allowed to take custody of an alien in the safe confines of a jail setting versus having to make a more visible arrest out in the community. When we make at-large arrests, not only do they drain our time and available resources, we do not know if an alien may have a weapon, or they might not be the only one we arrest when we encounter them with their family, friends, or colleagues who may not be in the country legally either. Ultimately, the reason we want to work closely with local law enforcement agencies is because we do not want to explain to someone or their family that their loved one might not have been victimized by a reoffending alien ICE could have instead removed. Every crime committed by a removable alien released from local custody by a jurisdiction which actively avoids cooperation with ICE is a preventable crime. As law enforcement professionals, it is frustrating to see senseless acts of violence and other criminal activity happening in our communities, knowing ICE could have prevented them with just a little cooperation. The fact is that 70% of the arrests ICE makes are at local jails and state prisons across the country. But we used to make more before sanctuary laws or policies prevented us from doing so. People have the misconception that when you limit ICE from working from law enforcement agencies, ICE will just go away. Nothing can be further from the truth. When our officers are not working in the jails, we are using those resources to locate and arrest criminal aliens and other immigration violators in the community, including at their homes and places of employment, a more dangerous undertaking for our officers and a more disruptive action within our communities. Simply put, a less effective method. There will be criminals we don't find, and if we do, it's often after they have been arrested for another subsequent criminal violation. Another misconception is that ICE conducts raids or indiscriminate roundups of people. However, every day before our officers leave our office, they know exactly who they are trying to arrest that day, usually after days of preparation, surveillance, and research. People also think ICE links into a community and starts making arrests in short bursts. But our at-large criminal alien and fugitive operation teams are working in your community each and every day. But almost every day, our media team gets calls from reporters asking, is ICE in our city? We are there each and every day. I said this earlier, but this bears repeating. We'd much rather take custody of criminal aliens in the safety of a jail environment instead of sending our officers out to perform the dangerous and difficult task of finding them all over again, because a law enforcement agency has refused to allow us to exercise our lawful federal authority to make an immigration arrest. Another myth is that ICE doesn't prioritize its limited enforcement resources, but in fact, nearly 90% of the people we arrest in the interior of the United States are convicted criminals, individuals who have been charged with a criminal violation and or illegal reentrants. Many sanctuary jurisdictions will also incorrectly assert that they cannot hand over custody of criminal aliens in their jails to ICE unless provided with a warrant signed by a federal judge. They are either willfully ignorant or patently disingenuous. The truth is that federal law does not provide a mechanism for judicial warrants to be issued for civil immigration violations. There is not a single judge or magistrate in this country, federal, state, or local, that has such authority. By statute, Congress has determined that only supervisory immigration officers will have this authority. This is one of the many ways in which the immigration system differs from the criminal justice system, and it is perfectly lawful. The truth is that every community is safer when law enforcement works together. There are a handful of sheriffs in the state of Georgia who work with ICE through this 287G program, the authority for which, again, comes directly from Congress. This program has proven to be an incredibly successful mechanism for state and local law enforcement agencies to work with ICE and is responsible for the removal of tens of thousands of criminal aliens from our communities. We unfortunately have seen numerous tragic incidents of aliens being released from custody after having been arrested for a state or local offense go on to commit another, often more egregious crime. Who wants to look those victims or their families in the eye and tell them that this crime could have been prevented? We are talking about crimes like assault, domestic violence, rape, and murder in some cases. So I'd like to share with you a case up to our neighbors in the north. As I said earlier, I'm in charge of North Carolina and South Carolina. Up in the Charlotte area, an individual was arrested last year following his arrest by the Charlotte Mecklenburg County Sheriff's Department for his arrest for felony assault and assault on a female by local law enforcement in North Carolina. The detainer was not honored, and the Sheriff's Department released him from custody a few days later. Shortly after his release, this individual is alleged to have reassaulted the same victim and is now charged with felony kidnapping, felony assault, and strangulation, and violating a protective order. ICE issued another detainer to the sheriff's office, which per the sheriff's current policy would also not be honored. Shortly after these crimes took place, this individual was rearrested by one of my fugitive operations teams in North Carolina, and he was prosecuted for illegal reentry and is now being indicted on felony kidnapping charges from that previous arrest after he was released. Sanctuary jurisdictions proponents often say that community trust in local police will be disrupted or downgraded if these local agencies work with ICE. But to be clear, we are not asking or forcing anyone or any agency to do our job. In fact, we have seen that when these released criminal aliens commit further crimes, their first target is often the very immigrant communities that sanctuary advocates claim to be protecting. And what does it say to the victims that do report crimes when law enforcement agencies turn a blind eye to the illegality of the person they just arrested and release him or her to the street, knowing full well that ICE was willing and able to remove that threat from the community? ICE has the rare ability within the law enforcement community to actually prevent crime. We can arrest and remove criminal aliens before they can harm anyone else again, immigrant and citizen alike. I want to thank you again for hearing from us and our agency on how our agency has been impacted by the laws and policies that squeeze law enforcement cooperation and information sharing. Thank you again for your time, and I'm happy to answer any questions you might have.
Well, thank you very much, Director, for your presentation, and thank you and your team for being present here today with us. At this point in time, what we'll do is we'll ask Chairman Petrie to return to the podium where he can give us a walkthrough in the legislation, and specifically the substitute. And we do have a number of witnesses signed up to provide testimony today. What I'd ask witnesses to maybe follow is substitute language that's really before the committee now. So if you have an interest in a part of the legislation that was previously introduced but isn't before us today, if you would maybe limit your comments to what's being proposed and is before the committee today. So,
okay. All right. Thank you, Mr. Chairman.
Thank you. All right, Representative Petrie.
Thank you, Mr. Chairman, and thank you, Director Giles, for making it very clear. Again, I have to say it again, this issue, as was just pointed out, clearly an issue of public safety. That's what this discussion is. So let's look at this new version. Is dramatically different from where we began. And so if you will look at the bill you have before you, the LC I read to you earlier, here's where we begin. We begin with a new definition. I mentioned to you earlier the inadequacy of the current definition of what is a sanctuary policy. And so we begin by clarifying that. And so you'll see here that a sanctuary policy means a law, policy, a practice, a procedure, a custom, formal or informal, as some of these are sometimes, written or unwritten, adopted or allowed by a state entity or local government entity which prohibits or impedes a law enforcement agency from complying with 8 U.S.C. Section 1373, which is the federal law which relates to communication between government agencies and the Immigration and Naturalization Service. So this is federal law we're speaking to. And it goes on, it mentions, or which prohibits or impedes a law enforcement agency from communicating or cooperating with a federal immigration agency so as to limit such law enforcement agency in or prohibit the agency from doing 5 things that you'll see itemized on the top of the second page. So this is very clear, improved language on sanctuary city than we have very nebulous language today that only speaks to communication. And so you'll see, A, complying. So if it halts the federal law enforcement agency from or a local law enforcement agency from complying with an immigration detainer, that would be a sanctuary policy. Complying with a request from a federal immigration agency to notify the agency before the release of an inmate, that would be a sanctuary policy. Providing a federal immigration agency access to an inmate for interview, that would be a sanctuary policy. Participating in any program with anything, a policy that would halt a local law enforcement agency from participating in any program or agreement authorized under Section 287, which the director spoke to earlier, which, by the way, is that code section of the Immigration and Nationality Act, which allows DHS to deputize local law enforcement agencies. And then E, finally, a policy that would disallow them from providing a federal immigration agency with an inmate's incarceration status or release date. So those are very clear and obvious policies, those 5 lines that make it very clear this is a sanctuary policy. And as you'll see, if you go back to the first page, you see the lines we've marked out are the current definition. So this is far more clear these many years later since this has been adopted. And then here's the real meat of the bill, and this is what we think we're very excited about. We believe this is something that everyone who believes in law and order and in protecting our population, if you believe in ensuring that we have public safety, if you will look at E, and it begins with number 1, this is the new route to halt these type of policies. An individual that is injured by the tortious acts or omissions of a person unlawfully present in the United States, or the personal representative of an individual killed by the tortious acts or omissions of a person unlawfully present in the United States, shall have a cause of action for damages against a local governing entity or law enforcement agency upon proof by the preponderance of the evidence that the existence of a sanctuary policy by the local governing entity or law enforcement agency is there and a failure to comply with this code section. So again, I don't necessarily need to continue to read through it, and I want Representative Single to be able to speak to it, but what this does here, if an individual in our community is injured or killed at the hands of someone who has benefited from a sanctuary policy where a local jurisdiction has refused to follow that which is federal law, it gives that injured party a route, a cause. And we believe this is right and just. Representative Singleton, would you like to speak to this?
I don't want
Please do.
Mr. Chairman, he said that so well, there's not really much to add. You know, the important thing for us, and one of the biggest reasons we gave you the substitute, is because we are laser focused in Georgia, and we are laser focused on what's the best way to protect Georgians and the people here in our communities. And we feel that the language in this bill, we hope that it avoids some of the political trappings that have a tendency of stopping progress and protecting Georgians, and it avoids some of those trappings, and it's laser focused on making our communities safer, and we hope that you'll take that into consideration. And when we do have questions, we do have some examples, if needed, of current policies in Georgia that we'd be happy to share, but we just thank you for your consideration.
Thank you to the sponsor for the explanation. If it's all right, members, I'll just kind of summarize here. And what I'd like to do is, we got a lot of witnesses who are in here. I'd like to hear from them if it's okay. And then if the sponsors can make time, we'll make sure all questions to the sponsors, there's adequate time for that at the appropriate time. But just to summarize then, your substitute is very different from the bill that was originally introduced, in that the substitute is just a redefinition of the sanctuary policy language, and then it's a cause of action.
Yes,
Is that
sir,
fair to
Chairman.
say?
That's correct.
Okay.
And Chairman, just to explain that, we began with both of our bills. They really began with a framework similar to what to Texas legislation. And as we worked on this, we realized that we really wanted to go in a new direction, as Representative Singleton described, that is a laser focus on public safety, and we believe this is the best way to do that. And so that's how we got here, Chairman.
And just to add one piece, Mr. Chairman, so the language you have in front of you today, the specific language that's in front of you for the sanctuary policy, it's just important to note that there are 5 other states that have utilized that exact language. 2 of those states did pass it into law, Texas Senate Bill 4 and Florida Senate Bill 168, 2017 and 19 respectively. Both of them have already been challenged in federal court. The most recent was November of last year, where a Obama appointee justice upheld it as constitutional. And so this language has already gone to federal court and has already been upheld as constitutional.
All right, thank you. If you gentlemen wouldn't mind having a seat at the table, and then what I'd like to do is, I would ask our witnesses today, respectfully, wanting to respect everyone's time and all the bills that we have on the calendar, what we'll do is we'll have 2 minutes for each witness, but I'm going to hold you to it. And I would ask that you limit your comments to the substitute that's before us here today. So that, I think, would help the committee members really get to hearing the testimony that they need to in order to make determinations as to the substitute bill to House Bill 1083. And of course, as was noted on the agenda, we're not voting on this today. It's a hearing only on this bill today. Okay, so what I'll do is, and forgive me in advance if I mispronounce your names, I'm sorry, please correct me, but Isabel Otero, if you would please come forward, and then Gloria Kalanko, if you would please stand on deck, ready to go. Glory, I'm sorry. Yes, ma'am. Yes, ma'am. Please go ahead.
Hi, good afternoon. Thank you. My name is Isabel Otero. I am the Policy Associate for the SPLC Action Fund. We urge you to oppose HB 1083. The SPLC Action Fund has seen these bills across the country. They are a result of an aggressive agenda by anti-immigrant hate groups like the Federation for American Immigration Reform. These type of unconstitutional bills become laws that serve as a tool for discrimination, because that is what was their intended purpose. The Southern Poverty Law Center is currently litigating against SB 168 in Florida, and we are making our equal protection claims, and we are not done with the litigation yet. These laws violate an individual's equal protection rights under the law by disproportionately affecting Black and brown people and any other Georgian perceived to be foreign-born. Therefore, this is an unconstitutional and unfunded mandate, and you must allow our law enforcement officials to continue to have discretion and authority that they need to do their jobs as they see fit and not as the federal government sees fit. The authors of this bill would like for us to believe that our law enforcement officials should just receive an administrative warrant from Immigration and Customs Enforcement, a federal agency, not a judicial warrant, with oversight in the courts, and that's enough to determine a person's status. That is not what an immigration detainer says. An immigration detainer is simply signaling that the federal government has more questions and more adjudication to do for someone's immigration status. This bill basically opens up our law enforcement to all kinds of liability if they enforce this administrative warrant. This bill takes away their discretion and may violate a lot of folks' Fourth Amendment rights. In Florida, we have a case against the Monroe County Sheriff's Department They violated the Fourth Amendment rights of Mr. Peter Brown. He was illegally detained in Florida's Monroe County Jail for deportation despite his repeated pleas to authorities that
Ms.
he was a
Otero,
U.S.
your
citizen.
time has expired.
Thank you.
Thank you very much. Next, Glory Kalanko, and on deck is Priyanka Bat. Thank you. All right, yes, ma'am, please go ahead.
Good afternoon. My name is Glory Afi-Kilanko. I'm the founder and CEO for Women Watch Africa, and we provide services to 23 African countries. I stand here to say that any bill that forces law enforcement entanglement with ICE will endanger our communities. And I make bold to say that in Clarkston, Georgia, here in the city of Clarkston where I live, we have had to live within a traumatic experience since 2017 after ICE raided our community. It became very difficult for women who are even victims of domestic violence to go to the common grocery store in the community because they became so frightened to walk in the neighborhood. We have had to work with these women to tell them that Clarkston is a small city and that we know each other and everyone is each other's keeper, because we come from a country where people in law enforcement have been our enemies because of the torture that we were subjected to. And so to have worked with women who are victims of domestic violence to prepare them to get used to the local police officers within the community, for them to see them as friends, as neighbors, as families, to now become so afraid to even call the police when there's crime, to even call the police when they are being victimized, to even call the police when they are being subjected to torture. This is going to make our communities terribly unsafe, as opposed to saying that this is for public safety. When we talk about public safety, we want to look at the public safety of each and every one of us that constitute that community, and not just one section. When the sponsor of the bill talked about the population of undocumented, using his language, illegal aliens who are in the jailhouses, he did not give us the ratio of American citizens who are criminals, who are equally in the jailhouse. So I would love to have that comparison. Thank you.
Thank you. All right. Yes, ma'am, if you'd like to come forward. And on deck is Swath with AAAJ. I'm sorry. Thank you. All right. Yes, ma'am. Thank you.
Thank you, Chairman and committee members. My name is Priyanka Bhatt, and I'm an attorney with nonprofit organization called Project South. We are here to urge you to vote no on HB 1083. ICE holds are, in fact, unconstitutional. Complying with an ICE hold is unconstitutional because essentially you are requiring law enforcement agencies to hold an individual in their custody beyond the time that they ordinarily would be held. This is done without a judicial warrant or probable cause, which is mandated by the Fourth Amendment, and several circuit courts and district courts have held that. ICE holds are erroneous. An ICE hold does not indicate anything about anyone's immigration status. Between 2007 and 2016, over 1,000 individuals were wrongfully detained or incarcerated on an ICE detainer. Between 2008 and 2012, ICE detainers were put on 834 U.S. citizens and 28,000 or more legal permanent residents, 10 of whom were from Georgia. They also create liability. Many localities have been forced to pay over hundreds of thousands of dollars because they've been sued for wrongfully detaining individuals. One city in Michigan was forced to pay a citizen over $190,000 after the city detained the individual and transferred him in ICE custody.
Yes, ma'am. Thank you very much.
Thank you.
Thank you. All right. Yes, ma'am. And on deck is D.A. King.
Hi, good afternoon. My name is Swathi Shanmugasundaram, and I'm the Policy Manager at Asian Americans Advancing Justice Atlanta. I want to first say that I'm thoroughly embarrassed and saddened that our legislature would not only allow but also give a platform to an anti-immigrant hate group like the Federation for American Immigration Reform. Quoting and giving credence to a hate group with ties to white nationalists and eugenicists is dangerous. This is not Georgia. Anti-immigrant hate group FAIR keeps lobbyists on its payrolls to advocate for legislation denigrating and vilifying immigrants. Last year in Florida, FAIR worked with another anti-immigrant hate group to introduce a heinous anti-sanctuary bill. FAIR writes on their site, as Rep. Singleton said, that he's modeled his anti-sanctuary bill here in Georgia on legislation introduced in Florida. This Georgia anti-sanctuary bill is similarly cruel, it's costly to our economy and state, and it bolsters the false narrative that undocumented immigrants are criminals. 2/3 of Asian American Pacific Islanders nationally are foreign born. 1.3 million Asians in America are undocumented. Georgia ranks 13th in the states with the highest number of Asian American populations. This legislation is dangerous for our communities. The state of Georgia has previously outlawed sanctuary policies and continues to strengthen those laws. This legislation does nothing but vilify our immigrant communities. Georgia is among the top 5 states for detention and deportation of undocumented individuals. This bill, if enacted, will further the separation of families, increase community distrust of police, and cost our state and local governments many millions of dollars through increased costs to counties, the judicial system, and litigation costs. It will also have a terrible impact on Georgia's economy and reputation.
Your time has expired.
Oh, well, thank you.
All right, on deck is Hugh Norris.
Good morning, Mr. Chairman, members of the committee. My name is D.A. King. I am the reluctant president of an organization, 501c4 nonprofit, called the Dustin Inman Society. I've been on this campus for the last 17 years of my life, working towards common sense immigration reform, which is also public safety. The Dustin Inman Society was named after a young man who was forever 16 years old because an illegal alien who was released from police custody and detention 3 separate times ran into the back of the Inman family car, killing Dustin and put his mom in a wheelchair for the rest of her life. I am here speaking on behalf of thousands of people across the country who support the Dustin Inman Society, including real legal immigrants and Americans of every description. I urge you to vote yes on the bill. I hope that if anybody is considering voting no, that it's difficult for most people in the public to get into their head that taking illegal aliens who have no right to be here, who are sometimes murderers, rapists, kidnappers, and child molesters out of our communities somehow makes us less safe. In closing, we should all remember that just last week there's a news story about an illegal alien who had already been deported and released from jail in Chicago, who days later went on to rape a 3-year-old toddler. I beg of you to consider this common sense bill and pass it out to the floor. It will pass. It's not unconstitutional. And by the way, everybody who says we should enforce our immigration laws is called a hate group one time or another. Thank you.
All right. Katie Stamper is on deck. Mr. Norris, if you want to come on up.
Good afternoon, Chairman and committee. My name is Hugh Norris. I'm from Cobb County. I'm representing myself. I've been on this earth about 3/4 of a century. And the reason why I say that, 35 years ago, I lived out in Southern California. California, as messed up as the state is, has a proposition referendum approach to legislation. When the legislators themselves are recalcitrant and the people themselves cry out for remedy, they do have a remedy. They can go door to door. They can get a petition signed. They can get legislation to be voted on for the people. I did that. I went door to door. We passed Proposition 187, which is so similar to what we're hearing about today. Proposition said, very simply, 187, no state benefits to illegal aliens except for emergency health care. We're compassionate. The law passed overwhelmingly by the people, but the political class crushed it. It was never enforced, and so forth. I just applaud this bill today. I think for a change, you all have something in front of you that's nonpartisan. Presumably, you all are loyal to the United States and Georgia and our Constitution and so forth. this should be a slam dunk. My only problem with the bill is that the penalties, the civil penalties, do not match the horrendous crime. In closing, my opinion is aiding and abetting, sanctuary cities aid and abet the invasion of the United States of America. This is harboring illegal aliens. The penalties don't need to be civil by the legislators or government officials. They need to be criminal, so these traitors, in my opinion, need to be in jail. That's the only way you're going to stop it. Otherwise, the fines will be paid by the taxpayers. I urge you to approve this unanimously. Thank you.
All right. Next up, Katie Stamper, and on deck is Darlene Lynch.
Good morning. My name is Katie Stamper. I'm a lawyer in Woodstock, Georgia. I've been practicing for about 30 years. 30 years ago when I was at UGA Law School, I was called a racist. I'm used to it. We've had a lot of people. Sorry, is that better? So anyway, like I said, 30 years ago when I was at UGA Law School, I was called a racist. And, so I'm used to it. I want to make a comment that the previous gentleman, I agree with everything that he said. And I also want to comment about some of the other previous speakers that were talking about whether or not this is unconstitutional or not. Whether it's unconstitutional or not is not a question that they're really speaking to. They're speaking to their sentiment that they want it to be unconstitutional. They're not speaking as to whether or not it really is. Now, when you get an ICE detainer, I have discovered when I went to the hearing with Casey Cagle and the city of Decatur in front of the IERB, that the sheriff of that city, Decatur, did not know what a detainer was, did not know that it was lawful authority, did not understand that there's no federal warrant for illegal aliens. So it's simply not a provision in the federal law. And so I would suggest to you gentlemen and ladies that the most important thing is to get better counsel. Sorry, this just isn't working for me. Is to get better counsel on what the law is. Because what you're really doing here is wading into an area.
Just back up a little bit from
Sure.
it, then it won't pop. Yes, ma'am.
You think that's better?
Yes, thank you.
Okay, thank you. Okay, so I think y'all really need to become a little bit more educated about this area if you're going to legislate. I do support the bill. I think it's a great bill because we simply have the federal government, which is reneging on its obligation under the Constitution to protect the states from invasion. It has a constitutional obligation. It's not doing it. So here we need to do everything we can to protect our citizens. And ladies and gentlemen, please remember that American citizens are suffering. Children
Your
cannot
time has
learn
expired,
English.
ma'am.
Children
Thank you.
cannot learn English when we have 140 languages in our schools. Thank you.
All right. Next up, Darlene Lynch, and on deck is Jacqueline Singh. And if we could keep down the background noise in here, and the reason that I mention is we have viewers who are watching on TV or watching it through the internet, and the background noise can be distracting and difficult. So I appreciate if you'd like to step outside the room to have conversations, that's fine. But I just would appreciate everyone's help with that. All right, now we'll go ahead and go forward with the testimony. Yes, ma'am.
Thank you, Chairman. I'm Darlene Lynch, and I'm here on behalf of the Coalition of Refugee Service Agencies. CRSA is a group of 21 nonprofit organizations that serve refugee and immigrant communities here in Georgia. We welcome thousands of new Americans each year and empower them to start new lives in Georgia and contribute their skills and talents to our state. I'm here to give you a perspective from our organizations working with this community and in this community. One thing that I'm hearing a lot today is that we're not listening to our local communities. Someone said, we don't want it to be a subjective decision by the local community. But for us, that's where the decision should be made. It's difficult to have a community that's diverse and that's coming from many parts of the world, and it's up to the local authorities and the local law enforcement to decide what those public safety priorities should be and what is the best way to make that community succeed. My reading of the substitute would require essentially that all communities participate in 287G programs when they are not mandatory. They should be optional. And so our law enforcement should decide, should I use our resources to respond to federal requests and detainers, or should I use them to keep our community safe in other ways? So keeping the immigrant community safe would mean using the resources to build that trust and to work against violent crime. I will also say that we've seen these kinds of bills come up in the past, and when they happen, they really impede our ability to do our work as well as service organizations in the community. There is a lot of fear, whether it's intended or it's not intended, and folks don't come and take advantage of services and of ways to engage in the community that helps them to succeed and to
Your
contribute.
time has expired.
Okay,
Thank you very much. All right, Ms. Singh, if you'd like to come forward. And on deck is Paula Hansberger, maybe? Thank you. All right, yes, ma'am.
Thank you, members of House Judiciary Committee. My name is Jacqueline, and I am here to testify in support of the HB 1083. And to the previous lady, this bill has nothing to do with the 287G, and I don't think any community should not be mandated. I live in Gwinnett County, and I am a first-generation refugee and legal immigrant. I am a naturalized U.S. citizen, and I love this country. My family and I escaped the Khmer Rouge genocide in the killing fields of Cambodia. The things that makes America different from any other country is the strength and fairness of the rule of law. Tolerating illegal immigration who committed a violent crime and providing a safe haven is unfair to the legal immigrants who respect our nation's law and insult those who do the right way. And they give future prospective immigrants little incentives to follow the law. Also, in today's hearing, you may hear many testimonies who support sanctuary policy that will use the term immigrant interchangeably with all three kinds of immigrants. There are legal immigrants who come to this country like my family, and the second one is those who come here illegally and didn't commit any crime. They just want to come here for a better life. And then there's the third category that are here illegally and continue to commit violent crimes like rape, murder, sexual assault, and armed robbery. The anti-sanctuary law only helps the third category. Last month,
All right, your
Chicago
time has
PD.
expired. Yes, ma'am.
Thank you.
Thank you. All right. Next up, yes, Paula. Thank you. And on deck, Desmond Hagre. Yes, sir. Thank you. Yes,
My
ma'am.
name is Paula Hansberger, President of Legal Immigrants for America, a 501c3 that gives a voice to the voiceless legal immigrants. Your decision on this bill will impact the quality of life of families of every race, color, and ethnicity in Georgia. The natural-born American and the legal immigrants do not need to live in a sanctuary city. Only lawbreakers do. I was born and raised in Nicaragua, and living there was similar to living in a sanctuary city. Citizens, poor or rich, build walls around their homes, some with barbed wire or broken glass on top. The windows had to have bars on the outside, and most head of households kept a weapon under the bed. We lived in fear. Do we want to live like that? Most Americans that have lived in a third world country do not want the United States to copy what goes on in Latin America. Even Latinos in the USA, whether natural born, naturalized American, legal resident, and even here illegally, prefer to live in a safe environment where the rule of law reigns. As for some of the angel moms that I have met and I have encountered their pain, really would would be for this bill that you are contemplating today. When it comes to separating families, it is the parents that control that, not the country. Why do people abandon their children in the United States, I wonder?
All right, your time has expired.
Thank you.
Thank you, ma'am. All right, next up, Desmond. Yes, sir. And on deck is Brant Frost. Yes, sir.
Mr. Chairman and members of the committee, thank you for allowing me the time to speak. My name is Desmond Haig, and I am with the Georgia Restaurant Association. I'm here to reiterate that our stance on immigration is that while we support comprehensive immigration reform, it is only at the federal level, including increased border security, a workable employment verification system, a worker program, and an earned path to permanent residence for certain undocumented immigrants. If you have any questions, feel free to contact me, and I will pass them through to our CEO, Karen Bremer, and our advocacy manager, Daniel New. Thank you again for
very
your time.
Thank you. All right, Mr. Frost, and on deck is Tom Haygood.
Thank you, Mr. Chairman. I will be brief. We've heard a lot of excellent stories today, and I will just give you a few statistics that I think will be helpful to you. The Investor's Business Daily recently reported in a poll within the last 2 years that 2/3 of Americans oppose a policy which would prohibit law enforcement from cooperating with federal immigration authorities when it involved a criminal illegal alien. And this is true across demographics. Majority of Hispanics, majority of African Americans, majority of white Americans, Asian Americans, all oppose a policy that would require local law enforcement to not cooperate with federal immigration enforcement. Also would like to point out, and these statements are available, easily accessible online, very strongly has, in previous administrations, we have seen both Republican and Democrats support taking a strong enforcement position. Bill Clinton, Hillary Clinton, Chuck Schumer, Harry Reid, Zell Miller, and many others. I'd also remind you that in the 1960s, Cesar Chavez, in the interests of protecting legal immigrant workers against their employers who were trying to bring in illegal immigration, worked with ICE, cooperated with federal immigration authorities in the interest of protecting workers and labor. And I'd like to conclude with, I don't think there's any real doubt among the members, the majority of the members of this committee, that your constituents would like to see you pass this bill. And I know that since you know in your hearts that that's the right thing to do, and since y'all do always what you think is right, that you will support this bill, and I do appreciate everything y'all are doing to represent our state. Thank you very much.
All right, next up is Mr. Haygood, and on deck is Leanne Rubinstein. That's our last witness. Yep.
Good afternoon. Thank you for this opportunity. I do want to remind us that for every story I've heard today about these terrible things that so-called illegal immigrants have done to others, there are countless stories of what illegal immigrants have done to save lives throughout the United States. To actually qualify these as all illegal, I think is totally wrong, because each of us, I think the word invader was used, we are all invaders of this country. This is a land of immigrants. This also seems like I'm up here again, deja vu again. We were looking at each other a couple of years ago on HB 452, I believe that was coming up. I think this is in many ways just a rewrite of a bill that was turned down 2 years ago. We are harming those who are greatly needed in Georgia. I think you'll hear that if you speak economically to people. But I want to say, as a faith leader, that the words "love my neighbor as myself" are not just simple words that mean I can break the law or not break the law. The words are simple. Love my neighbor as myself. I don't believe in tearing families apart, of which this particular bill would do. I do not describe immigrants as criminals, of which the greater majority, and I'm talking about probably 99%, and I'll have to get some figures on that, but I do not believe that we're looking at rapists and terrorists here. And I believe that everyone who comes to this country does have the right, through law, to go for asylum. So we're not breaking laws on that. So I urge, and I'm one of those people who does doubt the merits of this bill, that this be not passed. Thank you very much.
All right, and final witness that we have signed up is Leanne Rubinstein.
Thank you, Chairman, and thank you, everyone, for having me here. My name is Leanne Rubinstein. I'm the Executive Director of Compassion in Atlanta. And what I want to ask is, how many of you have taken different actions because of the coronavirus? Right? We fist bump, hand sanitizers off the shelves. Now, I want to repeat back some of the things that have been said to you by some of the people who are for this. I oppose it, and I urge you to oppose it for what's in your hearts, as someone just said, for the restaurant industry who brings so much money here to our state that we want to keep safe. We've already got 2 coronavirus cases here. So let's think about where we want to put our time and energy. Because if we believe, and I'm quoting from the bill, the presenters earlier, that we believe in law and order, we believe in protecting our population, protecting our public safety. We are laser focused on public safety and protecting Georgians. I ask you to laserly focus on the place that we should focus, which is keeping people safe. And if people feel that they have to go underground, if people feel that they are not safe in their communities because everybody is looking out to arrest them for no reason, I'm not talking about the criminal behavior. I think we can all agree in our hearts that's wrong, and none of us condone that. But what we do say is there are many, many people who are racially profiled. It would be wrong for me to say, every white man up here, you're probably part of the KKK. I hope that would hurt in your heart. It's the same kind of racial profiling that we do. And the honest answer is, when we talk about public safety, we need
Your time
people
has
to feel
expired.
protected.
Thank you.
So wash your hands.
All right. All right, so what we'll now do is, if you'd like to hit your buttons, if you have any questions for the sponsors who are before us, and we'll take a few questions today. I know we have some other bills on the agenda, so we'll take a few questions today, and then we'll move on to our other bills. So first of all, Representative McLaurin.
Thank you, Mr. Chairman. Thank you to the sponsor, thank you to the director, and thank you to all our witnesses for speaking to the bill. This is obviously a very important conversation we need to have because the values at stake, and I think if any of y'all know me, you know where I stand on some of those values. I think the biggest issue I have, and what I want to discuss with the sponsor briefly, if I can have just a moment to do it because I know we're pressed for time, is the liability component of this bill. I'm correct in saying you would agree that we already have a defunding provision in the code section this modifies. If a local government has a sanctuary policy, it's subject to defunding under, I can. Right.
So I'm sorry, you don't have a microphone. Would you mind standing at the podium, Representative Petrie? Sounds good. See it. You all will notice some of us members are shifting in and out. We have several committee meetings going on at the same time, so if you see that, just you'll know what's going on. So, all right, yes, sir.
So yes, right now what we have in Georgia today is a sanctuary description, a definition that is weak, as I described earlier, and the teeth that are available to use that term is simply the withholding of funds through the Department of Community Affairs.
And this bill does nothing to change that. So that hammer is still there.
Correct.
Okay. But what the bill does do is it adds more liability in the form of lines 36 through 50, which is a new private right of action, civil lawsuit against any municipality that has a sanctuary policy that a jury finds has caused a death, basically. Is that correct?
That is correct.
Okay. And this new liability comes with attorney's fees to prevailing party, which is usually, I guess, for those familiar with the civil justice system, attorney's fees is not the default standard. Usually attorney's fees are only awarded in cases of exceptional wrongdoing or misconduct. And you would agree too that normally attorney's fees are regulated by an exceptional showing of bad faith or litigious conduct or some sort of behavior by the defendant that's above and beyond just wrongdoing for which they could be liable, correct?
If the gentleman so states.
Okay, but there's nothing in this bill that attaches a standard to when attorney's fees can be imposed, right? It just says the judge can award them.
That's correct.
Okay, so I think what I'm trying to get at, and I think you could probably agree, this is an exceptionally large civil hammer that is potentially could be used against cities if they're liable under the code section. Okay, so
for parties who are injured, there was a lot of obfuscation here today in comments about trying to get us away, as is customary, from folks that do not want us to follow immigration laws. This issue is about public safety. And the aggrieved parties here that have this route are always and only going to be people who have been injured or killed by the negligence of that local law enforcement agency.
Okay,
yes.
but I mean, but effectively what we're talking about for a local government that's making decisions about whether to comply or not with a federal request is that they'll be thinking, if we don't comply with a federal request and then that person ends up being a perpetrator of a crime that hurts or kills somebody, we could be on the hook under I mean, that's the way that local governments will,
That's correct.
will look at this.
Yeah, so we completely agree with that statement, and we don't think it's a bad thing for the government to be concerned about what's going to happen to its people if it makes a decision. So we just wanted to recage a point, just because, and we do. If I can have 30 seconds of leeway, Mr. Chairman, answering the question, I just wanted to recage, and we appreciate the all the lobbyists that came up and to oppose it, and those of us, the citizens that supported the bill, and we just wanted to point out that our bill in particular, what this bill does is it gives a cause of action to the victims of crime because of failure to comply with federal law. It doesn't do anything else. There was a lot of people that spoke to the immigration policy, federal immigration policy, 286G application, the law enforcement going into your community, some of the comments made on that. That's not what this bill is doing. That's a great argument for a different day. What we are doing is giving a cause of action. If you are the victim of violent crime or a loved one's victim of a crime, you have recourse under this bill.
So, Mr. Chairman, a couple more minutes? Okay, I'll be as brief as possible.
One final question, if that would be all right.
One final question would be, okay, well, I'll
have other members.
I'll skip straight to the point, and then, next hearing, hopefully we can plumb this a little bit more. But my concern, and this is what I want to ask you about, is we're setting up a rock and a hard place. We're asking local governments, if you don't comply with the federal request, and by the way, the expansion of sanctuary liability, or not liability, but the definition, it's no longer just immigration status information. It's you must comply with detainers. You must comply with a request for an interview, which could be in person. We don't know. Does the city have to spend their own resources to take the person to the interview? What happens if the federal government just keeps the person when they're there? The state has no recourse. Now that person's in federal custody. So the question is, when you're looking at a rock and a hard place where you've already got these hammers and you're creating new ones, but what if the city does comply and the city does turn the person over to federal authorities under one of these new expansive provisions? I've got 10 tabs open on my browser of federal lawsuits that people have brought because of ICE detainers that do not pass muster under the Fourth Amendment. I represented a client in New York when I was there. You can check the campaign mail against me from last time. But when I was in New York, I represented a client who was wrongfully detained by ICE for over 3 years, was a U.S. citizen. Not a person with a green card. It was a U.S. citizen who, because they got the name wrong, this person sat in ICE custody, and they brought a federal lawsuit against the government. But theoretically, they could have brought a lawsuit against the local government because the local government, well, in this case, it wasn't a detainer. They didn't pass the person over. But if you turn over somebody, the local government's now responsible for that detention. So you've got liability potentially here under the Fourth Amendment and liability here that the bill creates. What is a local government, this is the question, what is a local government supposed to do when they are faced with liability for both sides and they have no idea at the outset when they make their decision which way that liability is going to go?
I thank the gentleman for the question. I think that from your question, if I'm taking your question wrong, please feel free to correct me. But you see, your problem appears to be with the federal law and the application of federal law by ICE, which is not a question that we would address in the General Assembly. About the difference between the rock and the hammer, I would argue respectfully that the laws that we have in the books that we're amending now were put in place in 2009. Those of us who are familiar with the Immigration Review Board, that was from 2011 passed into law to 2018 when we pulled it out. It was so ineffectual because of the lack of good language. To call it a hammer, I think, is wildly inaccurate. The current law as it is now is at best a unenforceable, vague threat. For an example, the Immigration Review Board in its entire existence heard 20 cases. 20 cases of violation of federal law. Of those 20 cases, it issued recourse twice, a $500 fine to the city of Atlanta and a $1,000 fine to Fulton County. And so just so you understand how important it is that we actually have, and again, the hammer that we are proposing is we want to empower the citizens of Georgia who are directly impacted by an egregious violent crime. We want to empower them to have recourse to say, this happened because my government willfully ignored federal law. We believe that it is a good and positive thing if a municipality, and if I have leeway, I want to read one sentence out of a 2017 resolution that was passed by the city of Atlanta, if I can have your permission to do so.
That's fine.
So we talk about the importance of the rule of law. This is a sentence passed by the City Council of Atlanta just 3 years ago. Be it further resolved that, in particular, Atlanta Police Department officials shall not arrest, detain, extend the detention of, transfer custody of, or transport anyone solely on the basis of an immigration detainer or an administrative immigration warrant, including an administrative immigration warrant in the National Crime Information Center database. That, sir, is egregious.
All right, Representative Kendrick.
Thank you, Mr. Chair. So I am assuming that there is an epidemic that needs to be handled by this legislation. So could you tell me how many cities and counties are currently not complying with 8 USC Section 1393?
Well, Representative Singleton just read to you the largest city in the state, and I agree with him. You allude to a hammer and what currently exists. I think the fact that he did describe these earlier will answer your question, Representative Kendrick, again, to present the cities that are doing this. But if we had a hammer, you wouldn't have this many localities refusing to enforce the law. Representative Singh, you want to address that again?
So it's 7 based on the 2018 audit, but it's changing constantly. So any moment in time, that is going to vary based off of not only the presence of policy, but the application of policy. I'd rather refer to the expert that deals with it every day and see if he can give you a better answer that you deserve.
Yeah, currently here in the state of Georgia, there's we have cooperation from most of our law enforcement partners. Excuse me. However, there's one county in particular that refuses to honor our detainers, and that would be Athens, Clark County.
All right, Representative Saints. Should be 6. Yep, should be on.
Thank you. I don't think it's picking up, but thank you, Mr. Chairman. Let me preface this question by saying, as a
No. Tell you what, will you move over and hit the button next to you? There, we're working. Thank you.
Thank you, Mr. Chairman. Let me preface these questions by saying that as a son of a first-generation Costa Rican immigrant and a second-generation Cuban American, I think I agree. I think I'm in uniformity with the authors in saying a more diverse Georgia is a better Georgia. This isn't about, from what I see, immigration. It's about compliance to our nation's laws. With that, on line 20, in regards to the new sanctuary policy, does this affect an officer's discretion in terms of a case-by-case basis? From what I read, it pretty much it addresses a uniform or a culture of in compliance, but not taking away that peace officer discretion in a case-by-case basis. Is that correct?
That is correct. That is correct, but I will look to legislative counsel that drafted this to nod an agreement as well to confirm. That is correct, sir.
I appreciate that. On in regards to line 32 and 33, regarding the 287G program, and this might be a question for the director. For the primary, is that a voluntary program for law enforcement agencies to take part in? And if so, how would this this bill affect that voluntary status of participating in the program?
So as I said earlier in my remarks, currently we have approximately 6 jurisdictions in the state of Georgia that cooperate, that are in the 287G program, with a few more, I believe, that are signed up to come back online with us. It is right now it is a voluntary program, but we encourage those counties to participate in that. In part of the 287G program is those individuals are being encountered in jail after they've already been arrested by the local law enforcement agency in that jurisdiction.
Appreciate it. And one more question that might be for the director. Does the agency have any information of the level of, in a sanctuary city, let's say Athens, Clarke County, or any other city that you, even if outside the state, what degree of those who you would otherwise have detained have left and have been found or apprehended in a different subpolitical entity or a different county or city?
Unfortunately, I don't have that information, but we can definitely try to get that back for you.
Would you say there are a level of individuals who are apprehended in a different community that does not have sanctuary policy, but by effect of that community that does?
Well, I can answer this. You know, I just got here about 3 weeks ago, and I come from Los Angeles, California, where that whole state is a sanctuary state, and I can't speak to there is some sheriffs out there that do keep track of this information of individuals that where a detainer was placed on the individual and it wasn't honored, and the individual was released back into the community based on current state law in the state of California. With that said, there's been studies done by the sheriffs and data produced, which I don't have handy right now, but I believe it's online through the Orange County Sheriff's Department, where they keep track of that information, and there's a lot of recidivism rates with these individuals that when they are released, they go back and reoffend in the immigrant communities that they come from, like I mentioned earlier in my remarks.
Thank you, Mr. Chairman. No further questions, and thank you for the work you all do in keeping all Georgians safe.
Whip Bodie.
Yes, thank you, Mr. Chair. Now, I've heard the sponsor state that this is about communication with federal authorities, but this also is about compliance. And taking a step further, it's almost stating to local authorities, you must comply. It's not you may comply, you must comply. And with that being said, to the authors, would this not put an undue burden on law enforcement agencies who are small in numbers and who do not have the resources to comply with the ICE detainer? And two, if they do comply with that ICE detainer, these smaller jurisdictions, who is going to reimburse them for these fees? Because ICE is not required to reimburse those fees. Is that correct? Or the cost?
Representative, thank you for the question. And all I can tell you is the federal law now says that they shall comply with an ICE detainer. So I think I think federal law is already pretty established on this. But yes, what we have now is a route for individual citizens who may be harmed by jurisdictions that refuse to support federal law and refuse to support also state laws that relates to sanctuary cities. It will give a means of recourse to individuals who are harmed. And, and of course, for those that are, we worked on this trying to make sure that it was our conversations were all about public safety. You're not going to see an individual harmed by some minor crime. This goes back to what I mentioned earlier. So, I mean, not to even include jails in this state, but just our state prison system today, sitting there this minute in the Georgia correctional system, 234 child molesters. That's at least 234 Georgia children, immigrant and non-immigrant alike, who were molested, maybe multiple times that. 162 murders, 127 rapes. And I heard the issue mentioned before, well, what's the percentage with the main? That's irrelevant. Yes, listen, that's irrelevant because the fact is that every one of these 1,600 crimes, sexual and violent, should never have happened. They should never have happened. And how many of these individuals had committed crimes previously and federal law was ignored? I don't know the answer to that. But I think that I want you to understand where we're trying to go. But I understand what you're speaking to. Maybe there's going to be a burden on a local jurisdiction. I don't think when I look at this, I see a great burden on law enforcement to make sure that they communicate with ICE. But I will concede that perhaps there's something there. I can't argue that. Again, my focus is on public safety, which I believe is more important.
I think it's important just to note too that if there is an undue burden, if your stipulation is correct, that burden exists currently, because it is currently Georgia state law 368023, I believe, that it is illegal in Georgia to have a sanctuary policy. That's already state law. So this bill, I just want to make sure everyone's tracking. We are not creating an anti-sanctuary section of the code. It already exists. So if there's a burden that's in place by enforcing this, then that burden should already exist, because they should already be enforcing the law. What we are trying to do is give a civil cause of action for a victim of violent crime because of their government who's sworn to protect them ignoring federal law. That's what we're trying to do.
Mr. Chair, can I have one
Yes, sir.
follow-up? In lines 25 through 27, we have in there, we're stating, or you're stating, complying with an immigration detainer, but we also are mentioning a judicial order. I just want to be crystal clear that an immigration detainer is administrative in nature, and a judicial order is signed by a judge. Now, I think any law enforcement officer that has a judicial order or a warrant, of course, are going to comply with that, because that is written by a judge, signed by a judge, and we have to comply through the full faith clause of the U.S. Constitution. It's no ambiguity there at all, but we have a ICE detainer or immigration detainer that is administrative in nature, and it does not have the judicial weight and power of a judicial warrant or detainer. Would that be correct?
Let's let Director Giles answer that question.
Thank you. So like I mentioned earlier, many of these sanctuary jurisdictions incorrectly assert that they cannot hand over custody of criminal aliens to their jails to ICE unless provided with an arrest warrant signed by a federal judge. The truth is that the federal law does not provide a mechanism for judicial warrants to be issued for civil immigration violations. There is no single judge or magistrate in the country, federal, state, or local, that has the authority to do this. The authority that Congress has enacted upon us is Congress has determined that only supervisory immigration officers have this authority.
One quick
Yes,
follow-up,
sir.
Mr.
One more.
If Congress wanted that to be a law, Congress can pass a law today to make that a law. Is that not correct?
We'd have to talk to the congressman on that, the congressional folks on that.
So it's not a law as of today. Thank you, sir.
All right. Representative Setzler.
Thank you, Mr. Chairman. Representative Petrie, I appreciate you bringing the bill. In any other setting, if there's duties, there's an obligation to follow through on them. If a physician has a standard of care to perform medicine a certain way, and they clearly ignore that duty and they fail to perform it, and as a result of that somebody dies, is someone held accountable?
Yes, sir, Representative, they are.
The people
consumer is protected.
The people who are on the panel today arguing against this proposition, do you think they would side with the proposition that there ought to be some cause of action to hold a doctor accountable who clearly has a duty, ignores the duty, and doesn't follow through on it?
I think they would, Representative.
And I think as the members on this panel contemplate that, I think they would concede themselves. They would recognize if there's a clear professional duty to prevent a death, someone clearly ignores that duty, and there's a death that comes as a result of that, there should be accountability. I understand your bill is doing only that. Is that correct?
That's correct, Representative, and that is why we removed all of those pages of the beginning bill. We stripped those out and started fresh and new with a goal to do just what you're describing.
Now, under your bill, if there's a person who is not a citizen but who's here in this country legally, if that person kills somebody in a community that has a sanctuary policy, they're not held accountable because it's not an illegal immigrant, correct?
Absolutely.
Okay. Now, if the city has a policy of not being a sanctuary city, they're fulfilling their duties, they don't have a sanctuary policy, and they're doing their best, and if a illegal immigrant were to kill someone, they still would not be exposed, correct?
Absolutely. That is correct.
It's only in the circumstance in which the city has a legal duty to fulfill and not have a sanctuary policy, and
an illegal immigrant commits a crime, kills somebody, it's only in those circumstances where they had a duty to not ignore immigration policies and someone died from it. The linkage of those two is the only circumstance and when that community could be subject to any kind of civil responsibility.
Yes, sir.
Okay.
That's correct.
How is that any different than any other professional responsibility anywhere throughout the I mean, is it not true that a school district, if a school district had a professional responsibility to act in loco parentis role, they clearly ignored that duty, and as a result of their clearly and negligently ignoring that duty led to the death of, heaven forbid, a child or somebody, wouldn't they be accountable?
Yes, sir, Representative.
So not only in the individual, private, professional setting, but also in the governmental setting, if there's a clear duty to do something, that is ignored, and there's a death that results, there's legal responsibility. That's the basis of our system. And I think the people that would ignore that are torturing an opinion to try to get away from what is obvious. This is a common sense proposition. And Mr. Chairman, at the appropriate time, I'd like to make a motion.
Hey everybody, I'm sitting in for Chairman Abstration while he goes over to juvenile justice to present a bill. There's some back and forth going on. This is a hearing only. But with that, is there any further, and I'm sorry I walked in the middle of this, so I'm not sure what's happened the last 5 or 10 minutes, but is there any further?
Let's not start over, Chairman.
Representative McLaurin.
Thank you, Mr. Chairman. I just want to try to clear up a couple things. The first thing is that federal law cannot mandate what state or local governments do to comply with immigration policy. That's a very well-established doctrine called an Anti-Commandeering Doctrine. The case is U.S. v. Prince. So everything that a local and state government does to cooperate with federal law enforcement has to be voluntary. That's why 287G is voluntary. In this case, the state's removing that discretion from a local government as to whether to cooperate or not. And that, I think, is the source of a lot of these problems, is that the state is saying, if you don't cooperate with federal requests, you will be subject potentially to civil liability. And so to answer the chairman's point about lawsuits, police and firefighters, as I understand it, are not liable if they fail to respond as first responders quickly enough to the scene of a crime. Or the point is, we're talking about a context where people making public safety decisions that are discretionary are going to be subjected to liability that is actually not normal in our system. This isn't a negligent slip and fall case where a restaurant owner doesn't put salt on ice. That's not the issue. The issue is people making decisions that don't owe individual duties because they're governmental actors, and we're assigning an individualized tort duty to a public safety setting where it's completely inapplicable. So I guess my question to you is, given that a state or local entity could be liable under the Fourth Amendment for transferring somebody into custody and creating a new arrest or seizure under the Fourth Amendment, what is the city supposed to do? Do you have, because again, you said this was a federal issue, Representative Singleton, but it's federal to the extent that it's a Fourth Amendment claim. But it's not federal to the extent that it could be a local government that's liable for participating in a mistaken ICE detainer that has no basis in the Fourth Amendment. So what is the answer from the sponsor about potential liability for local governments for following the dictates of this bill?
So I would, since you just said my name, I would say we're kind of blending two. I understand and appreciate your question. Kind of blending the two. The Fourth Amendment, feasibility or the validity of the Fourth Amendment claim is a federal issue. That's what I was talking about as far as federal issue. As far as Georgia law, it is already Georgia law. And avoiding sanctuary policy or having sanctuary policy is already a crime in the state of Georgia. It's already against the law. So what we are doing with the civil course of action, it's important to note that does not take away the municipality's decision-making authority. We do not mandate that they comply. We just are saying in here that if they willfully choose to continue to ignore federal detainer requests, they are subjecting themselves by their choice to the potential of a victim of a violent crime because of their lack of complying with federal law to be liable for civil action. So that is still the choice of the municipality. It does not mandate in this bill. It merely updates sanctuary policy. The choice is still for that municipality, and then they will suffer the repercussions if they choose and it leads to the death of one of their citizens.
Representative Sains.
Real quick, because I know there was mention to an officer's liability. Being privileged enough to having sworn as a deputy sheriff in Camden County, I believe that most officers do take the oath to uphold the Constitution of the U.S. and the state of Georgia and all applicable laws within. And would it not be fair to assume that not having adequate protection in state law and ensuring that there's not an agency or municipal or county policy that makes that officer, restricts that officer from upholding those laws, would create violation of oath of office issue?
Good point, Representative. Thank you. I agree.
Reluctantly, I think I have to yield the chair here. Not in charge anymore.
All right. Well, thank you, everyone, for letting me check into another committee real quick. I see Chairman Setzler's light is flashing. Did you have a question or? Okay. So what we'll do now is we typically just give the sponsor the last word. If you just want to briefly give any final information for us. I know we've covered this extensively over the past hour and a half.
I think we've covered it, Chairman.
Okay.
I think, I hope that all I can do is try to emphasize again that this is an issue of public safety. No matter how anyone tries to describe it to the contrary, which is often the case, this is an issue of public safety. And I like the way Representative Setzler described this gives people who are injured by what I would describe as reckless policies a recourse to a local jurisdiction that refuses to enforce ICE detainers. And so in the interest of public safety, we bring you this bill. We made it dramatically different than where we began, expressly to deal with some of the issues we've discussed today, to remove all of that language that was much more broad, and to narrow the focus on making sure that people who are harmed by the result of these policies have some means of recourse. And I appreciate the opportunity, Chairman, for us to hear it and to hear both sides. It's important that we weigh both sides, learn what we can from each member, and proceed accordingly. And I appreciate you giving us the opportunity to do that. Representative Singleton, would you like to say anything as well?
All right.
Thank you, and I want to thank the
Thank you
director
very much
for being here today.
So what we'll do is I will ask Chairman Setzler to going up to the podium to get ready for House Bill 1086. If anybody's shifting out of the room, that's fine, but what we'll now do is move on to House Bill 1086 as introduced. All right, if we could have some order in the room, we any conversations, if you would just take your conversations outside. We our time is very precious here in All right. Okay, very good. We already got it for this bill. You want me to add? Yeah, I'll put you on. Thank you. All right, thank you, Representative Singleton. All right, Chairman Setzler will recognize you at this time to present House Bill 1086 as introduced, LC 289697.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to come before you today.
All right. Can we see if, okay, everybody's making their way out. Very good. All right. Thank you. Representative Setzler, please proceed.
Thank you, Mr. Chairman. Members of the committee, we bring before you today House Bill 1086, a bill that I think addresses a very timely and important issue for this General Assembly. It's one that plays itself out many times every year. This isn't a philosophical thing that might be something that maybe someday could ever come up. It's something that comes up hundreds and hundreds of times each year in Georgia, and that's the issue of civil asset forfeiture, and under what conditions should a civil proceeding happen to make somebody who's either been arrested or accused, perhaps not yet accused, but somewhere in the process of becoming accused, to have their assets subject to a civil proceeding which could be forfeited as part of the overall civil and criminal proceeding for the underlying offenses. Today, Mr. Chairman, members of the committee, I'm going to bring before you 3 points I want you to walk away with. There is a legal demand for us to act as a General Assembly on 1086 this year. There is a practical, day in, day out, actual practical demand that affects regular people. And there are some specific constitutional questions our current state of the law raises that I'd like to wrap up with before I conclude my presentation. At the direction of the chair, I would just tell members of the committee I've been asked not to spend too much time going through this. We could kind of go through and do a real detailed rundown. But what I would say for members of the committee and those who are listening today, on February 20th, 2019, a major change happened with respect to how this law is positioned for the state of Georgia. On February 20, 2019, the United States Supreme Court, by a 9-0 decision in the Timms v. Indiana case, ruled that forfeiture, through civil asset forfeiture, cannot exceed the maximum penalty that would be possible if a criminal conviction were brought. There was the case in question in the Timms case was a gentleman whose Land Rover was seized as part of civil asset forfeiture. It was valued at $42,000. Charges were brought against him that would have brought a maximum fine of $10,000. And after working its way through the system, it was held again by a 9-0 opinion last year, unanimously by the United States Supreme Court, that a forfeiture is in fact, the dollars lost in a forfeiture are synonymous with criminal penalties. And the total amount that's lost in a forfeiture cannot exceed that total amount. That Tim's holding is here. I can share that with members of the committee that would like to see it. But February 20, 2019 was a sea change in how this law can be handled moving forward in Georgia, and that is one of the bases in which we bring House Bill 1086. What HB 1086 seeks to do is to put the proceedings of considering civil asset forfeiture only upon conviction. So under current law, people who are suspects, after being arrested, potentially bonding out, a civil asset forfeiture proceeding can proceed even before an indictment is finalized. It can happen between indictment and a criminal case, and in most cases is concluded well before a criminal trial commences. So I bring before you today, we have a legal demand before us as a General Assembly to reconcile our existing law under OCGA 9-16-15 with the Timms case, which this General Assembly has not had the opportunity to yet do. I think House Bill 1086 does exactly that. That's the first thing, Mr. Chairman, we have a legal demand before us. Secondly, the issue of actual practical demands, things that are happening out there in our state that affect this issue of civil asset forfeiture. Is the pre-indictment potential for someone to have to yield their assets through a civil proceeding, post-indictment pre-conviction, is that the appropriate setting? The question comes back to, are the outcomes we're seeing day in, day out appropriate? Now, I will tell you that in many cases across our state, the way this plays out in hundreds of cases each year, I'm confident are probably okay. That the proceedings the way things are done by law enforcement are probably running consistent with a subsequent criminal conviction that would be coming. The challenge is, in many cases, they're not. And what I would bring before the members of the committee, there's a Northeast Georgia county within the last 2 years. Case was brought. One particular officer in this county, I'm not going to name the county, but one particular officer was responsible for, in the period of time under question of 1,400 traffic stops, made 47 arrests that year, And in a 90% Caucasian county, of the 47 arrests, 44 were of African-American victims, or African-American accused. And in the cases of these traffic stops, the civil asset forfeiture was used to seize assets and cash in many of these cases, up to an amount of nearly $200,000. It was brought in a civil case. A lawsuit was brought by one of the gentlemen that was who had his assets seized. He was independently of great means, was able to bring a case, and a federal judge in ruling on the case found the history of this particular law enforcement agent truly shocking. Even though civil asset forfeiture was the mechanism to seize these $200,000 of resources, it could be cash in people's wallets, or it could be assets that were within the vehicle in these stops. The opportunity for abuse exists in ways we see these kinds of very, very grotesque outcomes. I'm not proposing this is the rule. I'm proposing, though, that when we have an opportunity, we have a system that has the potential for abuse prior to conviction, we're going to see these kinds of circumstances all too often. Mr. Chairman, I could walk through a number of other cases. I was asked by some members to bring some. I've got a case of a middle Georgia county in which a restaurant owner that had video gaming machines, one of his employees actually broke the law. An employee made a cash payout of $500 rather than making a payout of merchandise, which is the current structure under the law. As a result of that, the restaurant owner's assets were seized, more than $2 million of assets. There was no criminal offense at the time the case was well advanced. It was only as a very substantial criminal or civil defense began to be mounted that subsequently charges were brought, because the way that the proceeding was lining up and the claim being made, wait a minute, there's no criminal charge against me, there's been no indictment. As this civil case proceeded, an indictment was brought, but it was seen consistent with what we're seeing more frequently than we can ignore in our state. This issue that the ability to seize assets through a civil proceeding becomes really the center of gravity of the legal proceedings against an accused, as opposed to a movement towards a criminal indictment for that which is otherwise presumed to be an underlying crime. And what this bill recognizes is if people are breaking the law and we can bring criminal convictions, it's appropriate that the assets that are used in the performance of that crime should be subject to civil forfeiture. Those assets, I believe, can be, rather than used by, at this point, in the case of those that have been accused and convicted criminals, those assets then can be used by law enforcement in ways that can be beneficial to our law enforcement interests as a state. HB 1086 recognizes that interest. There are different opinions on that, Mr. Chairman, that perhaps those assets should be used for victims, but 1086 recognizes there's an interest in using those assets by law enforcement and for law enforcement interests, but only in those circumstances in which there's first a conviction.
So is it fair to say that your bill is really a procedural matter, that or it's really a procedural issue, that the forfeiture proceeding would still be initiated as it is currently? It would just be stayed until a conviction is returned in the case?
That's right, Mr. Chairman. And people have brought some questions to me. I welcome questions from anybody, across law enforcement or across our criminal justice system that would ask to ensure this committee does its job in getting the details right. I would remind members of the committee, as folks have come to me and they've asked this question: what happens if a truck, for example, is seized, and it's a depreciating asset that could lose significant value over potentially 3 or 4 years of potential appeals? There's a provision in 9-16-10 that allows those assets to be liquidated, the money held in trust, even in interest-bearing accounts, as our law contemplates. So there's not this diminution of value that becomes a loss to the government if those assets are able to be retained. This bill changes nothing about the process of what can be seized, when it can be seized, from whom it can be seized, how the assets can be disposed of. All this does is recognize that hearing for forfeiture has to first be predicated by a conviction. It can't happen as it does today, which may be a surprise to many members of our committee. It's happening today pre-indictment. There are circumstances here that people are arrested, assets are seized, and before there's even an indictment that's finalized, a forfeiture proceeding is completed.
Well, and maybe our experts in the audience, witnesses here, can correct me on this, but my understanding is it even could be initiated within 10 days of arrest, and when the defendant is still in jail, maybe even pre-bond, if bond is even an option. So I guess just a few follow-up questions quickly. So what about, under your bill, law enforcement potentially is now going to have to hold property for an extensive period of time waiting for the disposition of the criminal case? Because that could take years, right? So how do you plan to address that?
Well, again, as I alluded to earlier, in 9-16-10, there is a procedure for liquidating assets. My bill proposes to make no changes to that. That's, again, law enforcement. I'm using law enforcement broadly between prosecution and law enforcement agencies themselves have some discretion about how that's actually done. Again, in the context of depreciating assets, our existing law already contemplates that issue and provides broad ability to liquidate that, turn that into dollars. That can be an interest-bearing account, so it can be actually appreciating, not depreciating over time. That eliminates the need for extra storage lots and some of these kind of things that could provide some of the same logistical challenges that we undergo in holding evidence. I would say parenthetically, evidence storage is no small thing for law enforcement, and that's not going to change, obviously, under this. We hold cars, bikes, chainsaws, all kind of things as evidence, and as people that design and plan for law enforcement facilities. That's a significant thing. But this gives the ability for these assets potentially to be liquidated, so that we're not compounding that in ways that would be, in my opinion, unsustainable.
So just to walk through this then, so a forfeiture, if your bill is enacted, forfeiture proceeding would be initiated and stayed pending the outcome of the criminal case. The assets could then be liquidated and the money held in a trust-bearing account, and if the defendant is the owner of the property is ultimately found guilty, then that money would then be released to the law enforcement agency for use as it is currently.
That's correct.
Okay.
I would say, Mr. Chairman, if somebody had an ownership interest in the property, the bill does allow them, if they believe that they're, for example, the person whose assets are seized, or a family member could still pursue a hearing prior to conviction to make the case that their assets shouldn't be held, that they're should be released because they weren't associated with the crime.
So you anticipated my next question. My next question is circumstances where property or money seized and the defendant has no ownership interest in it. So there is existing law to allow for forfeiture proceedings under those circumstances, and that would just be handled as it is currently.
That's correct, and that the lines 14 and 15 of the bill address that directly, Mr. Chairman.
All right, I have a few questions. So first, Representative Bodie.
So, thank you first for bringing this bill. It seems to me, because my day job, I actually deal with forfeitures, that you are codifying a practice what judges are already doing what they can do. If it's an agreement between the state and the criminal defense attorney, and signing an order to do exactly what you're doing with this bill, to stay the forfeiture proceedings until either a plea is recorded and filed by the clerk of court, or it's an actual conviction. And at that point in time, the stay will definitely be lifted, and the forfeiture claim would move forward. But your bill also allows for a waiver of that stay by the defense and defendant. And isn't it not true that mechanism may be used as a negotiation tool between the defense attorney and the prosecutor when trying to resolve the case, the substantive criminal case and the forfeiture matter as well?
I couldn't have said it better myself, everybody. Thank you for that. That's exactly what it does. It does provide options, but the presumption of it happening prior to conviction is not there.
Vice Chairman Reeves.
Thank you, Mr. Chairman. I have a lot of thoughts on this, and I'm going to limit what I say right now and see how the discussion goes. But the the abuses, I believe very strongly that the abuses of the procedure that we've identified should be addressed, but I believe they should be addressed individually. I believe that there is a public way to do so and to draw attention to that. And I do not believe that the entire underlying system should be changed based on the isolated incidents where I'm not gonna pretend that there haven't been situations that I acknowledge that there have been some issues here, but I believe that those need to be addressed individually and that we do not need to change the underlying procedure here. And one of the concerns I have,
Mr. Chairman, to my good friend from Cobb, I appreciate I appreciate the sentiment. I think there's always a desire by this legislature to take the lightest touch that we can take. There might have been 3 or 4 years ago an ability to take a sort of a piece-by-piece approach to kind of work around the fringes. The challenge here is, with the Timms case in 2019, which we've not wrestled with as a General Assembly, it is very clear that the maximum criminal penalty available is the maximum amount that can be seized and retained through civil asset forfeiture. So if we think about that, just if we pause for a minute and ask ourselves, until you have an indictment and charges that are brought and a conviction that is yielded, how can you know what is it a $10,000 ceiling? If it's stacks, it's 2 count, $20,000. How can you know what that amount is until we actually have a conviction in the post-Timms legal environment? We don't have it. And given that, I think the gentleman's instincts are right. Let's take a small step in this direction. Let's not take too big of a bite. I don't think our General Assembly really has a choice to not address Timms head on, given those facts.
The other concern I have that I want to talk about right now is in B, acquittal or dismissal shall preclude civil forfeiture proceedings. I mean, as we frankly have discussed much in the last few years, and we've particularly discussed a lot this year about the concept of alternative prosecution programs and how many charges result in something other than a conviction, and the completion of certain programs like diversion programs does lead to a dismissal of your charges. And I think that what this is doing is that this is allowing a person who otherwise would be subjected to a civil asset forfeiture a windfall or a break, because they also were able to take advantage of an alternative prosecution program that resulted in something less than a conviction. And that is something that I don't think that that's a road that we need to go down in this.
Well, to the gentleman's question, I'm certainly friendly to the discussion around diversion. We don't want to create, we don't want our diversion programs to create perverse sort of unintended incentives in these ways. So, as I shared with the chairman, that's perhaps a separate conversation that can happen within the context of this bill. It's certainly not my intention to create a circumstance where the civil asset forfeiture proceedings create perverse and unintended impacts on people taking a diversion route, or that a prosecutor wouldn't want to offer a diversion route that might be better for someone who perhaps is a first offense drug-related offender. We wouldn't want to create incentives where prosecutors scratch their head and say, you know what, we think there's a real interest for forfeiture here, but we don't want to give them this other opportunity. We don't want to create, again, what I would call perverse incentives that would turn us away from the spirit of criminal justice reform. And I don't think we're bound to that. If this committee comes up with a way to parse that, I'm certainly friendly to it. But that was not my intention.
Representative Burchett.
Thank you, Mr. Chairman. Thank you, Chairman Sessler, for bringing this piece of legislation. That's something that I agree we need to take up here. And I agree with Bodie in that we're really codifying something that's already in practice, particularly down in my area of the state. And I know there have been some folks that maybe are taking advantage of the way it's written now. I wanted to get your thoughts on one thing here. On lines 11 and 12, the court shall stay civil forfeiture proceedings during the pendency of criminal proceedings resulting from related indictment accusation. And we brought up the scenario where someone is arrested and forfeiture proceedings could start while arrested but prior to indictment. Do you think we need to go ahead and collect after arrest, that we stay proceedings after arrest, or do you think it's already captured here?
I believe that's captured. What I'm not seeking to do is I'm not seeking to, and the bill does not do this, I'm not seeking to interdict the ability to seize assets when assets are available. I know sometimes these things are fleeting. So this bill does nothing to affect a law enforcement officer or agency on a scene or at a stop or in an investigation from being able to seize assets they can seize today. It's simply the disposition of those, what the final disposition is going to be through these proceedings wouldn't happen until post-conviction. So.
Thank you for that answer. And one more, if I may. So you believe that with this language where it's proceedings resulting from indictment, you think that prior to indictment we are still capturing, any property that may go through the process of seizure and forfeiture prior to the indictment?
I know that's happening, and that will continue to happen. I will tell you, it does give me pause when you think about, and this bill doesn't change this. So this bill's not going to fix this to the extent it's a problem. When people's assets are seized, in fact, there's cases, I had a number of cases I was going to bring today. I was asked to bring a few, where assets are seized, to including bank accounts of businesses. Their ability to mount a legal defense is majorly inhibited by their financial assets being seized as part of a forfeiture. So there's really an issue of access to justice, even in a civil setting, because of the way it plays out. This bill doesn't change that. If you think that's a problem, this bill, that will continue. This bill doesn't fix that. But that is a thing.
Thank you.
Chairman Silcox.
Thank you, Mr. Chairman. Do you think in any way, Chairman Sessler, that this would aid gangs or criminal gang activity in any way, since it takes away that immediate threat of the asset being taken? I'm just concerned.
Sure, it's a fair question. I want to remind members, and I appreciate that, and maybe we need to, maybe some of us need to repeat, certainly may repeat this to myself again and again. This bill has no impact on the seizure of those assets. Those assets will be seized exactly as they are today. If there's a crime scene, there's drug money, there's drugs, there's other property, guns, other things that are believed to be part of the criminal enterprise. Those assets will be seized if this bill should pass exactly as they are today. It's just the final disposition of those won't be ruled on in a civil proceeding until after that's done. So all the assets that are being seized today will continue to be seized, taken out of the hands of potential criminals from a criminal enterprise, and there is no change under this bill about the seizing those assets. It's just the final disposition won't happen until after conviction.
And you think that this doesn't give them any incentive or extra hope that their assets, would get the assets back?
Well, I think the question is, are there under what circumstances do we want there to be acquittals that there's no I don't want to answer three questions. I don't think so. No.
Okay.
I don't see. As I try to think through this, I'm not going to make up hypotheticals, but I think the answer is no.
Okay. Thank you.
All right. First witness we have is Brad Rigby. Excuse me. Yeah, if you'd come on up, please.
Mr. Chairman, is Mr. Rigby's coming up. Can I make one more point to the committee before I wrap? Is that possible?
Actually, if we could go ahead and move into witnesses. Okay. We looks like we're going to have to move rooms this afternoon, and so I'm working on that to get our next room where we'll be moving to so we can continue the discussion.
Thank you, Mr. Chairman.
Mr.
Yes, sir.
Chairman, members of the committee, thank you for letting me speak today about asset forfeiture. I wanted to address just a couple of things really quickly that were addressed in the prior presentation. The Timms versus Indiana case does nothing to change Georgia law, and it does not require any change in Georgia law. The U.S. Supreme Court in 2019 just addressed the 8th Amendment procedure for excessive fines and forfeitures regarding a heroin and a vehicle that was used in that particular case. The state of Georgia has been doing excessive fines and forfeitures since 1994 in the case of Thorpe versus the state, 264 Georgia 712. It's a 1994 decision that gives a 3-part test for evaluation for excessive fines and forfeitures. So basically Indiana was just behind the times. Georgia has been ahead of the time since 94. There's a new decision that actually came out in 2008 changing the 3-part test, and Howell versus the state for those for the 3-part test that is used. But Georgia has been using the excessive fines and forfeitures clause for 30 years. In my experience as a prosecutor, being the district attorney in the Cordial Judicial Circuit, I've also worked for the Prosecuting Attorneys Council, and for 6 years of that, I primarily did asset forfeitures for the entirety of 38 counties in South Georgia. And I have continued to do those within my office as district attorney at present. What we see as the problems for requiring conviction in this are just manifold in many respects. One, who has to be convicted? If you have a multiple co-defendant case, you prove possession with intent or something else on one defendant. Is it required to be proved on every defendant in the case? Because many times there are those situations where money is found, multiple defendants are in the car, multiple defendants are at a house where the assets are seized, or multiple people have those issues. We also have, the bill runs afoul of having an innocent owner and that the innocent owner and the same person, or the defendant charged with the case, would have interests that would be aligned together. Many times they are not aligned together and don't have the same interest in the property, and this would prohibit an innocent owner from getting their property back until after a conviction, or if or not a conviction is given. Many times in the prosecution of these cases, we are awaiting a GBI crime lab. With all due respect to the crime lab, we have been in a backlog for drug cases, for drug analysis, sometimes 6 months to a year to get some of those analysis back. Therefore, we are waiting to indict. Most DA's offices around the state of Georgia are waiting to indict until we have the crime lab, because there are so many variations in chemical components now that we have to specifically indict for. That's going to be 6 months to a year out before an indictment. We're going to be waiting sometimes in circuits that have just 2 sessions or 2 terms a year. We're going to be pushing those cases back for years, 4 or 5, sometimes even 6 years to even get a case to the courtroom to trial. And so this is going to completely delay those proceedings in those respects. So I just wanted to address that. This is kind of backdooring what the bill already says, what the civil asset forfeiture proceeding already says. The standard of proof in these cases are preponderance of the evidence. That's what the bill, the present bill says. This is now requiring a beyond a reasonable doubt measure for civil proceedings requiring a conviction, which requires beyond a reasonable doubt conviction. And so that is going to be basically a backdoor issue.
I'm sorry, if you could just suspend. So
Sure.
I'm told that juvenile justice has just finished in room 506, which is on the same floor around the corner. And so if it's all right,
Yeah, sure.
if we could just hit timeout, we'll start with you in the
Okay.
next room.
Sure.
Thank you.